May I come in, sir?
आजा बेटा.
Good morning, sir.
Good morning. बैठिए.
Thank you, sir.
Aqsa.
Ji, sir.
What does Aqsa mean?
So, Aqsa means one who aims to achieve the great heights. It also means pure soul.
Okay. Introduce yourself.
So, as you already told my name is Aqsa Assadullah. I am from Kupwara, presently residing in Badgaon. I have completed my schooling from Jawahar Navodaya Vidyalaya, Khanpura, Badgaon. And then I have completed my BA LLB from Central University of Kashmir. Apart from academics, my hobbies include writing diary and spending time with children.
Why do you want to become a prosecuting officer?
So knowing the role of a prosecuting officer in the administration of justice, it attracts me towards it. It's very interesting that prosecuting officer, despite representing the state, still has to follow the administration of justice irrespective of the fact of winning or losing the case. Apart from that, I have my inclination towards criminal proceedings, and also I want to be financially empowered. All these are the reasons for me to become a prosecuting officer.
You said that you are inclined towards criminal proceedings.
Yes, sir.
Then you can become a lawyer also. Why this
Prosecuting.
If you good criminal lawyer, or you, why? Be honest. Be honest.
So there are multiple reasons for it. Number one, I want to join as a public servant. Number two, I want to be financially secured and empowered. Also, as I said, the role of the prosecuting officer attracts me towards it. For these other reasons.
What is this concept of one nation, one election?
So one nation, one election means it basically aims to synchronize the state elections with the Lok Sabha elections. So it has the purpose, as I said, that to synchronize between state elections and Lok Sabha elections. It can be on the single day or within the single time frame. It has been in the recent news because the government is pushing towards one nation, one election.
What reason the government is giving to push for it?
So government is giving the reason that it will reduce, there are certain reasons given by the government. Number one, for example, is that it will reduce the election costs, which are already huge amount of costs are inculcated in elections. It will reduce such costs. Also, it will basically, the government will focus on governance rather than elections and all the campaigns of elections.
Can you come again?
So it will, number one, it will reduce the cost of elections. Number two, the government will be more focused towards governance because the time of elections will be reduced. The government will focus more towards governance rather than conducting elections, taking part in elections.
Does it anyway affect federalism?
So, there are the apprehensions that the state issues will be overshadowed by the national issues, but I don't think it will affect.
What was the procedure up to 1967 of holding these elections?
Sir, I'm not knowledgeable.
पहले तो simultaneous elections ही होते हैं.
Central elections were held together after 1967.
फिर जब डिसोल्यूशन हो गई कुछ असेंबलीज वगैरह की तो देन उसी का फिर रिपरकशन हो गया कि ये.
So I think will be my question. Suppose we will go for one election in the whole country. Tomorrow again this problem arises. There is a failure of constitutional machinery in any state, and again president's rule is governor's rule is imposed. Will it not disturb again this one election, one nation at that time? What will be your views about continuing with 356?
So at the time of emergency.
356 is when constitutional machinery.
Yes, failure of constitutional machinery. Sir, can you please rephrase the question?
Suppose when tomorrow Parliament passes this legislation, there will be one election throughout the country, or states as well as Union Parliament. But immediately after enforcing this, we are holding election pan-India for states as well as, and after a gap of certain period of time, constitutional machinery of any state fails. 356 is imposed. What are your views with continuity of 356 in such circumstances? Will it not again lead to the same where from we have come?
then elections will have to be ultimately held at
They are all it. There's a constitutional bar. You cannot keep governors who for a limited period of time. You cannot keep continuously in the constitution. What are your views? How to cope up with this situation at that time?
So I think, according to my opinion, there has to be the provision to deal with this issue. Since it has already been an issue, so government needs to frame a policy with relation to that. Also, government needs to address this issue also, particularly as they are aware that this situation might.
In other words, you will say that that state will be re-election will go for the remaining period on. Suppose 1 year has elapsed, then the remains 4 years on. That election should be done only for that 4 years. Can it be one of the solutions?
Yes, the government can address this issue. Yes, the government can take it.
Your view is that the government has to address solutions before going for such legislation.
Yes, the government has to address this issue before actually making it a law.
चलिए
अच्छा, अपनी बेटी का मैं मूड कोर्ट कॉम्पिटिशन में आपने हिस्सा नहीं लिया?
Yes, sir.
किस मूड कोर्ट कॉम्पिटिशन में आपने हिस्सा ले लिया?
So Kashmir University National Moot Court Competition, which was held in 2018.
क्या टॉपिक्स था वो आपका?
So it was the problem was based on murder.
Murder.
Yes, sir, 302. Apart from it, constitutional validity of death penalty was also one of the issue.
Tell me what, in your view, is it right to award capital punishment, death penalty?
So keeping in view the society of India and the crimes which happen in India, I feel that the present situation of death penalty as related to the rarest of rare cases doctrine, I think that is the solution for the validity of death penalty. In terms of rarest of rare cases, in terms of different guidelines passed by the Supreme Court, those guidelines are taken into consideration, and I think by those guidelines, death penalty is constitutionally valid.
Death penalty is constitutionally valid. That is valid. What is the procedure for suppose that Sessions judge awards death penalty to a person if he who has committed murder? He is convicted in the murder. What is the procedure adopted thereafter after convicting him? Is there any other formality to be completed?
So according to section 366 of CRPC, when the sessions judge passes a death sentence, it has to be confirmed by the High Court also. Yes, sir.
What is that called? Is that confirmation? Is it a reference or revision?
So it is not a revision or reference. It is just a procedure laid down in section 366 of CRPC that the death penalty of sessions court has to be a
procedure. Okay, so it will go to the High Court or somebody will take it?
Sir, the court will refer it to the High Court.
The reference is there. You are saying it is not a reference in the side. It is not. The court has correct. It is a reference.
Yes, the court has to.
So it will not. So moto court will refer it to the High Court for confirmation.
Yes, the court will refer.
This is the procedure to be adopted in the murder.
Yes.
अच्छा, आप मुझे बेटी बोला आप आपने मर्डर पे ही मूट कोर्ट कंपटीशन ले लिया. Suppose A investigators need to kill D, but the offence is not committed. Is A guilty of commitment of murder?
Yes, sir. A will be guilty.
Defined to this.
So it is given in the chapter of abatement itself that even if the abatement 108 of 108 of Indian Penal Code deals with it, that irrespective of the fact that offence has been committed or not, the abater will still be liable for the offence. So offender will be liable for abatement to murder.
But offence has not been committed.
Yes, sir. Offence has not been committed, but his intention was to abet him. So offence whether related to that person has been committed. He has instigated. B will not be liable, but A will be liable.
Is abetment itself an offence or it is a procedure?
So abetment. So abetment, when it is done for some offence, then abetment becomes an offence.
It's itself an offence.
Yes, sir. It is an offence.
Is it prosecuting officer or it is public prosecutors now?
So it is according to section 24 of CRPC, it talks about public prosecutors. So, but the cadre of prosecuting officers ultimately become public prosecutors.
What, according to you, what is police report?
So police report has been dealt under section 173 of CRPC. Police report is basically a report laid down by the police before the court in order to give their conclusion whether the offence has been committed or not. There are two types of police reports. It can be challan, which we call as charge sheet, which means that police comes to the conclusion that offence has been committed. Or it can be closure report, where police comes to the conclusion that offence has not been committed. However, the police report is not binding on the court. Court can form its own opinion.
In which circumstances the court can direct the police to investigate a matter?
So usually re-investigation is not directed by the courts. However, courts under their inherent powers can direct the re-investigations. For example, if the investigation, if it comes to the knowledge of the court that investigation was totally modified based on extraneous circumstances or facts, under such circumstances, under the inherent power of the court, they can grant the re-investigation.
Is it reinvestigation? Is there any term used as reinvestigation in the CRPC?
So CRPC itself doesn't talk about re-investigation. It talks about further investigation under Section 173, Clause 8. Yes.
What is zero FIR?
So zero FIR, although the term has not itself been used in the CRPC, zero FIR means where the FIR is registered outside the jurisdiction of the police station and then referred to the jurisdictional police station.
What is the urgency of this zero FIR? Why this zero FIR?
So maybe for example, the crime is committed somewhere and the victim gets outside the jurisdiction, for example, usually rape offences. Under such circumstance, police cannot deny registration of FIR at the immediate step. So in the Lalita Kumari and after post-Nirbhaya, the zero FIR provision has been inculcated. In fact, in the proposed bill, Bharatiya Nagarik Suraksha Sanhita, zero FIR has been expressly laid down.
You tell me regarding recently there is a judgment on dying declaration. You must have gone through it. Supreme Court laid down a law for dying declaration. Any idea what is it? They have laid down certain guidelines when this can be taken into consideration, when conviction can, based on dying declaration. They have laid some guidelines. Any idea?
So there are guidelines.
No, I talk about recent. It is just last week.
Sir, I'm not able to recall the guidelines as laid down in a recent case law, but I know the general guidelines laid down by the Supreme Court in different landmarks.
They reversed the judgment of Allahabad High Court.
I'll read upon it.
Okay, you go ahead with what are the guidelines?
So dying declaration can, there's no hard and fast rule whether the dying declaration can be the substantive piece of evidence or not. However, the court has laid down twin tests. Number one is that the dying declaration should be made voluntarily. Number two is that it should basically inculcate the trust of the court. That means if the court knows, if the court trusts that dying declaration is true, then supplying these twin tests, dying declaration can be the sole basis of conviction.
There is something very important you are missing.
So trustworthiness and voluntarily basis.
There is something very important which has been made part of dying declaration now.
I'm sorry, sir.
They said that the victim should have every apprehension of dying. There should be every apprehension in his mind that he is going to die.
So means they have ultimately inculcated the England law.
This was actually earlier also, but this has been reiterated by the Supreme Court in recent judgment. They have reversed the Allahabad High Court judgment. A brother had killed 3 people. One of them had given this dying declaration. Then he was convicted. High Court confirmed that. Then Supreme Court said no. If there is an iota of suspicion regarding this veracity of the victim, we can not rely on this. Anyway.
So can prosecution cross-examine its own witness?
Yes, sir.
How?
So Section 154 of the Indian Evidence Act deals with it. Basically, when the witness turns hostile, under such circumstance, with the permission of the court, the prosecution can cross-examine its own witness.
It can cross-examine its own
Yeah.
witness. You have said that if it is hostile,
Yes, sir.
can hostile witness be treated as a witness for conviction leading to conviction of any trial? Is it admissible once she is hostile?
So there are case laws related to it. The case laws, the Supreme Court in different case laws has laid down that just because a witness has turned hostile doesn't mean that his earlier statement cannot be considered. However, since he has turned hostile, court has to be extra cautious with relation to the conviction based on the
What part of his witness can be
considered.
considered for trial not taken?
Sir, 154 clause 2 lays down that prosecution can rely on his earlier statements also.
The line is so style. Can his apostille witness be considered for conviction of the accused in the trial? And if yes, you have said yes, which part of the hostile witness can be used by the prosecution?
Sir, his statements he made corroborated with other. So I have read earlier section.
No, only that part that will be basically which is in favor of the prosecution.
Yes, sir.
That part can be considered by the court at the time of.
Will court of its own motion declare anybody as hostile witness?
No, sir. So it is the prosecution who, if feels that the witness is giving statement against him, then the prosecution can.
Is court obliged to consider this plea of the prosecution that he may be treated as hostile witness? Is court obliged to consider this?
Sir, I'm not sure, but I think that court is not obliged. So it is my interpretation, although I'm not sure.
Manika Gandhi case आपने पढ़ा है?
Manika, yes, sir.
What link that has with this criminal procedure code and all this? It has hit Article 21. What were the facts of that case and how it is linked with the criminal justice system?
Sir, Manika Gandhi is a very landmark case on Article 21 of the Constitution of India. It says that it basically interprets Article 21 as the life can be taken by just, fair and reasonable procedure. So since just, fair and reasonable procedure has been laid down, it has been held that the just, fair and reasonable procedure can be the procedure as laid down in CRPC.
What procedure?
So any procedure, be it related to any crime, different procedures are laid down in CRPC.
Suppose there is a special procedure prescribed in some act. We are applying that procedure, but this procedure is inconsistent with the criminal procedure code. Will that sustain? Special procedure sustain?
Yes, sir.
How defined?
So in case of conflict between special laws and the procedure laid down in CRPC, the procedure laid down in the special acts will prevail, subject to obviously just, fair and reasonability test.
You tell me, Section 34 is a substantive offence?
Section?
Section 34.
No, sir.
Then what it is?
So it is not a substantive offence. It basically inculcates the common intention. That means if the crime is committed by two or more persons in furtherance of common intention, then the all will be liable as if the act has been done by a single person alone.
So why it is not part of Evidence Act? Because then it becomes rule of evidence only. Yes. It is not part of evidence.
Yes, sir.
Your views. Why it should have been? Do you think it should have been part of Evidence Act than being part of the IPC?
Common intention.
Because in 34 it is a rule of evidence. Yes, sir. There was commonality of intention. That is the only thing we derive from it. Yes, in IPC, what we see, there are the offences. Yes, 34 in itself is not an offence. No, sir. It defines only the rule of evidence. Yes. Then don't you think that it should be part of Evidence Act than IPC?
So I'm not able to frame the opinion at the moment.
You should form your opinion. See, question is, I tell you, when Supreme Court laid down a law, they said that the statement under 164 has to be through prosecution, right? I was asking the same question. I contradict. I said no. I said then the impartiality of investigation is diluted, because when the police get as the witness, to get a statement recorded, meaning thereby when we talk of the police statements with the police, so it is as good as, because in court, as you know, police will take a person, go to the court.
It has a bar of 25.
The question is the veracity of 164 goes down. So my point is you should form your own opinion. That's my point. When I said why 34 should not have been part of Evidence Act, why IPC? When IPC we have only offences. Yeah. We have list of offences and punishments and all these things. It doesn't describe anywhere the procedure. Procedure is then RPC, then Evidence Act. That's my point. Is you should try to give your reason. If this way, then why this? Why not this? That's only you can always differ with what we say or with anybody, but you should have the reasons to speak. So, what is Section 37 of IPC?
So Section 37 says that if two or more persons cooperate in terms
37, I talk about 37.
of 37 of IPC. So it deals with the cooperation with relation to the commission of acts. If different persons cooperate in the commission of the act, then they will be liable for the offence.
Can death sentence be reviewed?
Death sentence be?
Reviewed. Can a criminal review lie against a death sentence?
No, sir, it cannot be reviewed by the same court. The review lies with the same court who has passed the sentence. It cannot be reviewed by the
What is the
same
remedy?
court.
Because we are losing one remedy.
Yes.
See, in every system we have different kinds of remedies. We have review, we have revision, we have appeal, second appeals in civil law, all those things. But when you say that a review cannot lie, so an opportunity to the accused or the convict, the one opportunity he loses. Do you agree to that?
So there are multiple options available for that person with respect to death penalty. Already, since Sessions Court passed the death penalty, it has ultimately passed to the confirmation of High Court. So already it goes for the confirmation of High Court. That is why we will not.
Let's say suppose High Court has confirmed it. Will settle this criminal first appeal lie before the High Court? I give their session day.
Yes, sir, it will lie.
It will lie.
Yes, sir, appeal will lie. So, yes, sir. Sir, the procedure itself mentions that if after the confirmation of the death sentence, which has to be signed by two judges, after that, the death sentence, appeal lies towards that. The provisions itself lays down that.
Appeal with criminal first appeal will lie before that.
Yes, sir, appeal will lie before the High Court.
Suppose it is accused has been acquitted. Will state prosecution go against that judgment in criminal first appeal before the High Court?
Yes.
And what is the procedure? How they can go in the criminal first appeal before the High Court?
Sir, under Section 384 of CRPC, which deals with appeals against convictions, the state prosecution, as directed by the district magistrate or state government, can go to against that acquittal can go towards the appeal.
District magistrate also.
Yes, the district magistrate gives.
Yeah, one is please.
She says district magistrate or the government. You said both.
So with respect to inadequacy of sentence,
District magistrate doesn't have any competence. It is the government.
It is government which is competent. Government has to sanction.
sir, as far as I'm able to recall, district magistrate.
See, prosecution has to seek sanction of the government for filing a criminal first
Yes.
appeal against the act of any things proper that the case has not been properly. Prosecution has not led the case properly before. So tell me now, BDK, is High Court appellate court in the criminal or it is a trial?
So it is appellate court, also trial court. It has an original jurisdiction also.
It has got original jurisdiction.
Yes, sir, it has got original.
चलो बेटा लॉ के बारे में बहुत सी बातें होगी. ये मुझे बताओ, ये करालपुरा किस असेंबली कॉन्स्टिट्यूंसी में आता है?
Sir, sorry,
Oh, it should be पता होना चाहिए.
And the latest delimitation में वही करालपुरा ही was.
जो नया डिलिमिटेशन हुआ, कश्मीर प्रोविंस में एक कॉन्स्टिट्यूंसी ऐड हो, उसका नाम बताओ.
Kupwara.
वारा तो ऑलरेडी थी. त्रेगाम की कॉन्स्टिट्यूंसी तो आपका शायद उसी में आ रहा होगा.
करालपुरा आएगा
कहीं
करालपुरा भी त्रिगाम में ही आता है.
Sakralpura different तहसील है.
But constituency of your
त्रिगाम. थोड़ा बेटा जनरल नॉलेज का भी रखो ख्याल. बाकी तो ठीक. ये mens rea क्या होता है?
So mens rea means guilty intention. It is an essential element towards the commission of the crime. If any person commits a crime, two essential elements have to be proved. One is actus reus, which means the action. Second is the mens rea, which means the intention behind the crime.
बढ़िया बेटा. कॉन्फिडेंस भी ठीक है, लेकिन
Antestatium nus mens rea.
Yes, and act itself does not make a person guilty unless done by guilty intention. Yes, sir.
It makes sense. किस लगी कहाँ से आएगा?
So Latin.
हाँ, ये पढ़ लेना. इनमें से पूछे जाएंगे क्वेश्चंस.
all the best. You are doing
You are doing good. You have improved a lot.
Thank you.
और ऐसे ही कंटिन्यू कब है तुम लोग?
So 8th go ahead.
करो अभी तैयारी.
आपको जरूर वहाँ पे you will be asked your opinions and your views about certain things.
So 34 का क्या reason है?
क्या किस चीज़ का reason?
So why has it been put into?
I said, what is your opinion? There is no reason. I said, what is your opinion? Should have been part of evidence? Because as a lawyer or as a prosecutor, tomorrow maybe a question is raised in the court. So you should be able to form the opinion. My point is you should be critically analyzing the things and positively also, not only critically, but you should be able to form opinion on certain things. That's my point.
थोड़ा यूनिफॉर्म सिविल कोड के बारे में भी पढ़ लेना,
जी
रखना अपनी जगह से रेस्पॉन्स तैयार करना।
कोड आजकल उसका भी एक चल रहा है।
yes
ठीक है बेटा,
All the best.
thank you so much sir